Hey guys, welcome to this video. This is John Watts. I'm a consumer protection lawyer. We have a great question here from Ryan's two kids. It says, I'm being sued by Discover Bank in circuit court. I'm not sure what state this is in, but generally circuit court is kind of the bigger court. Okay. It says, I was served paperwork of the civil summons by the sheriff. In their exhibit, there's something about arbitration that mentions us and we have a couple weeks to file an answer. Can I file a motion to compel arbitration? And if the court allows the case to be arbitrated, how does Discover collect their money from me? Can it go back to court to force me to pay? So fantastic questions. So let's talk about a couple things. What is an arbitration agreement? How do we compel or force arbitration? And then if we lose that arbitration, how does the bank, in this situation, Discover Bank, how do they get their money? So first of all, an arbitration agreement is just part of the contract between you and Discover Card, where you have agreed and they have agreed that if either side wants to be arbitrated, that any dispute will be arbitrated. Typically, there's an exception for small claims cases, but this would not be small claims. Now, you have to read the terms of it, but typically that's the only exception, small claims type of case. So an arbitration agreement says that you will not be in front of a judge, you will not have a jury, you won't have a class action. Instead, you'll be in front of, typically it's one arbitrator, and that usually is a lawyer, depending on what organization you go with. It almost always is a lawyer. And it may be a retired judge or else a very experienced lawyer. And then that arbitrator will make the decisions in the case. So you could think of them as sort of the judge and the jury. Okay. Now, the key is to read it carefully, make sure that it applies, and that it applies to the parties, so you and Discover, which normally it will, and then the subject matter where they're trying to collect money from you. Make sure that that's not carved out or an exception. And then, so that's the arbitration agreement. Number two is, how do you compel the arbitration? Well, typically you would ask the collection lawyer, hey, I see here that we agreed to arbitration. Will you agree to arbitration? And if they say yes, then normally both sides will prepare something for the court that says, hey, we agreed to arbitrate this. Okay. And you name the organization. Normally it's going to be AAA, American Arbitration Association, or JAMS, JAMS. I personally prefer JAMS to AAA. I mean, they're both fine. JAMS, you tend to get a little bit more experience. Arbitrators, maybe some former judges there. And so I just happen to like it a little bit more than AAA. And sometimes it'll give you the choice. Sometimes they'll say we only do AAA or we only do JAMS. So you can get the other side to agree. If they don't agree, then you can file a motion to compel arbitration. Remember, a motion is just a request to the court for something to happen. It could be a motion to continue or postpone the trial, or a motion to compel, to force the other side to do something. It could be a motion to dismiss, motion for summary judgment, motion to set a trial. It's just a request in writing to the judge. So you would say a motion to compel arbitration. Here's the arbitration agreement, and then specifically point out how you meet those requirements. And then you go to arbitration. Now you can settle in arbitration. You can get a trial, we call it a hearing, arbitration hearing, and they give an award. And so you can do all that just like in court. Now, if Discover Bank either wins the arbitration or there's a settlement and you don't pay, then typically they can take that award or that agreement for arbitration and go to court and then have the judge enforce it. So normally when the judge compels arbitration, they will sort of hold on to the jurisdiction of the case. Okay, but they'll say, now you guys go over here and arbitrate, and then you come back and I will enforce that arbitration. Sometimes done a little bit differently, but there is a mechanism for them to enforce the arbitration award, either with the original case or they take that award and go file a new case, and then they have the power of the court to garnish and things like that. So it definitely is a strategy. Some people just say, oh, well, always do arbitration, they'll just give up. No. And frankly, they think that when we sue, they go, well, we'll make this consumer lawyer arbitrate and he'll just give up. No, we don't give up. Okay. And depending on the amount, I would not expect Discover to give up. You may get a better deal because a lot of times it's incredibly expensive for them in arbitration. Okay, it might be they have to pay $1,000 or $3,000 or maybe even more. So you do have to look at that. If you go to the arbitration, whatever arbitration agreement website, if it's AAA or JAMS, go find typically called the consumer rules, and you may have to pay a very little amount, and that's normally only if you're suing, but it'll give a fee schedule. Okay, and some of it depends on what arbitrator. Some arbitrators are $300 an hour, some are $800 an hour, and they got to pay that. Typically, it's all going to be Discover paying that. So make sure you know what you're getting into, but it could be a good move. And then in arbitration, just understand those rules. They tend to be a little bit more informal than court, but they still have rules there. So anyway, I hope that is helpful to you, and keep us posted. Let us know how it turns out. And thanks for the great questions. I really appreciate it. You have a good one. Bye-bye.